Good morning. One of the subscriber wanted to know how to argue the cases. First of all, you must understand what was your case and take some hint points. Date of occurrence, if you are arguing for final stage, where how many witnesses were examined, what is relation between the plaintiff or the accused side or complainant side between the witnesses 1 to so many, then what all are the documents filed and whether that those documents are legally valid or substantially proved or that document was from the proper custody of the person who marked it. All these points should be noted down in a, if you are capable of memorizing it on your mind computer, there is no necessary, but however still it is far better if you have take down some precise note so that you can argue serially, chronologically, may not skip one or 2 points. Then question arises, you know what is meant by sir. Everybody we used to call, if we want to give respect, we will call sir. Sir means submitting in royalty. That was when everybody before commencing their say for the king, they say sir. Sir means royalty. Submitting in royalness, I think, sir. That is short term sir. So but here before judicial process, we used to address the court as your lordship, my lord, me lord. Before the high court and before the lower court, we normally address the judges, your honor. So better use your honor or my lord for every sentence, not in between the sentence. Suppose when you start commencing argument, if judges not properly listening or some other factors are drawing his attention in some other area, you have to repeat your argument. And when judge want to express certain things about his opinion or which may also sidetrack or distract your argument, you have to consume that. Then you, what your lordship says is correct, but your lordship, I want to stress my point on this way or that way, you can again state. And one more vital aspect in argument was, do not argue your vital points immediately and try to win over the case by proudly thinking in your mind that this point will be the best point to address. You try to argue that point very later, keep it as a trump. Sometimes what happens, the judge who read the paper simply say that what is that you are arguing, all silly points. You are not arguing the main point. Do not get annoyed by that comment. You feel that is blessed. What is happening inside the court may not be known to outside the clients. If you get success, that is sufficient for your multiplicity, uplifting of your career. The another aspect was, whenever you argue the case, if anybody interrupts your argument, opposite side, do not get angry or distracted, because that is one of the art of the argument. You always try to argue by distracting the other side and do not allow the other side to distract. Finally, this will be the form of argument. You slowly, precisely tell what for your prayer. This is an application for grant of anticipated bail. That is not sufficient Let the judge put question, what all are the offences. You say for offences under section so and so so and so. The date of occurrence, who was the complainant. Like that, bail also, date of arrest, so many things. And according to me, if you are arguing for bail or anticipatory bail, again I plead you that you do not argue as if you are arguing trial or getting acquittal. You simply argue, we are following adversarial system of criminal jurisprudence, Westminstership. Therefore, you may remain silent. You can simply say it was falsely implicated and draw the attention of the court that your client pre-trial imprisonment may not only cause deterioration to the health of the petitioner and also financial and other repercussion on your family members, because you are a sole winner of the breadwinner of the family. This is where you have to argue. But how to argue trial, final stage of the trial, that is totally different. That I will come tomorrow. And how to argue civil cases is also totally different. Before that, I want to say that whenever you completed your argument and other side is arguing certain facts, countering your argument, you need not worry, it is the judge to decide. But if he is giving new facts which was not on your book or record, then you have to answer for that. If that is complicated question, you better get a date for getting instructions. And that way of argument, cost proceedings also, you must, instead of whenever you argue for cost proceedings, you must say that these all are the vital points which was not considered by the court at the time of taking cognizance. That should be your point. You should not say that the case is posted one, I am innocent, something else had happened. That may be drafted in your petition, but at the time of arguing, you must substantially argue that you are the taking cognizance is not in accordance with the procedure contemplated in the Code of Criminal Procedure. That should be your argument in cost proceedings. This is writ petitions. When you argue the writ petitions, that is another important thing. You must understand what is writ of certiorari, writ of mandamus, writ of habeas corpus, or writ of prohibition or declaration, whatever it may be. You must go through the concept, the introduction of those writ, the history of writ. Slowly you can, but those things need not be argued. And don't think that you read certain things, judge may not know, judge may know, but that would have been faded away because of his age. But if you argue slightly, if you realize the judge understood that, don't elaborately discuss. I have seen so many young advocates, energetic, curiosity, intelligent, but even though the judge is inclined to grant order, he still goes on argue and expressing whatever he in his mind, whatever he learned, and disturb the judge's mind. And finally it won't get order, or say the judge may simply adjourn it or dismiss it. This way of argument we should be we are clutch and gear the vehicle. When you drive the vehicle, you have to control your clutch and gear, and finally brake means you are not driving the vehicle, you are stopping the vehicle. That is most important in argument also. You have to balance your argument. You should be alert in how to use this clutch as well as a gear, and so that you can drive your vehicle according to the aim of your reaching the destination. So this will be my preliminary discussion about how to argue. Tomorrow I will come to argue stage by stage about how to argue criminal side, how to argue criminal trial, how to argue civil side, how to argue other cases. Best wishes.